Members, let's begin. We have a heavy agenda today. So without further ado, item 1, information paper issued since the last meeting. The panel has not issued any information paper. Next item, that is items for discussion at the next meeting. The next regular meeting is scheduled for the 8th of July 2025 at 4:30 p.m. The administration has proposed to discuss 3 items. 1. Airport City and Hong Kong International Airport Dongguan Logistics Park development. 2. Enhancement of existing concessionary tax regime for maritime service industry and provision of half-rate tax concessions for commodity trading business. 3. Developing the silver economy. Well, we're going to need more time for all these 3 items, so I suppose the next meeting will also be adjourned at 7 p.m. So coming back to today's agenda, we have an agenda in relation to local vessel operators, and then another important item, work of the Competition Commission, as well as the next one, which is equally important, development of low-altitude economy. So let's observe the housekeeping rules. And we now start the next item, which is new requirements for applications or revalidation of local certificates of competency held by local vessel operators. We should continue with the discussion at the last meeting, but let me first invite the administration to come in. Members, if you have questions, please press the request to speak button now. Let me welcome Mr. Shi Qiang, Deputy Director of Marine, Ms. Amy Chan, Deputy Secretary for Transport and Logistics, Mr. Klaus Chan, Principal Assistant Secretary for Transport and Logistics, and Mr. Jamie Ng, General Manager of Marine Department. Now we have 7 members waiting to ask questions. I'll read out the names and then I will invite the administration to walk us through the paper, starting with Mr. Chan Yong, Chairman Guang, Frank Ki Yik, Edmund Wong, Chen Siu Hong, Eric Yim, and Stephen Ho. I will give each member 4 minutes. Please observe the time limit. Now, I'll give the floor to Deputy Secretary Ms. Chan. Thank you, Chairman. Good afternoon, Chairman members. Now, coxswains and engine operators, collectively referred to as operators, are responsible for operating local vessels, and they are essential for maritime safety. To ensure that operators are qualified to perform the duties concerned, we require all operators to hold local certificates of competency. At the moment, there is no need to conduct any medical examination to verify the fitness, and that the validity period of the certificates will be so that the medical examination will only expire upon the operators reaching the age of 65. And in order to enhance maritime safety, having regard to the licensing requirements in other places and having regard to the opinion of medical consultants engaged with the study, the Marine Department will revise the arrangements, and that will introduce a medical fitness certificate. Now, a 2-tier system will be adopted. Tier 1 covers all new applicants for the issuance of any level of local COCs and applications for revalidation of their COCs. So at the time of submission, the applicants will be required to submit a medical fitness certificate issued by a recognized medical practitioner. For Tier 2, we target operation of high-risk vessels. That means passenger-carrying vessels, so on and so forth, and the relevant operators will need to go through medical assessment once every 5 years. Now, in relation to this proposal, we consulted the industry in the second quarter of this year, and we are also going to amend the examination rules for local certificates of competency and examination rules for pleasure vessel operator certificate of competencies. In relation to the new applications or revalidation of the applications for local certificates of competency held by operators of high-risk vessels, additional terms will be added to the licenses. Now, I will now give the floor to Mr. Shi, Deputy Director of the Marine Department, and then we'll be happy to take questions from members. Mr. Shi? Indeed, for local COCs held by local vessel operators, there is no requirement for medical examination to be conducted. Apart from an eyesight test for coxswains and pleasure craft vessel operators, there is no need for any medical examination to be conducted all the way until they reach the age of 65. Now, the interdepartmental working group was previously set up, and having received recommendations from medical consultants engaged, we agreed that a new medical assessment model should be adopted. Now, we decided to adopt a two-tier system, and for Tier 2, it involves Class 1 vessels carrying more than 100 passengers and Class 2 vessels which are oil and gas and town gas LPG tankers. There are about 600 such vessels in Hong Kong. In drawing up the medical assessment protocols, we have considered a number of factors. Basically, there are three. For example, any medical condition that would cause the operator's inability to perform the duties, and also medical condition that may completely cause incapacitation of the seafarer within 30 minutes, and also other mental health conditions that may affect the sensory, cognitive, and mood functions, etc. So there are altogether 9 such risks, as you can see in the form, and upon recommendation by the experts and medical consultants, we have prepared the medical assessment form. Questions are included, and they are put to the applicant to assess whether the applicant is qualified to operate a vessel. It also includes some basic medical checks or health examination, including blood pressure, blood sugar level, etc. In the course of medical assessment, if the applicant is found to have certain physical conditions, not necessarily a disease, which may hamper his ability to operate a vessel, then the Marine Department will be informed. In fact, starting from 2 years ago, we have been conducting over 20 briefing sessions, engaging industry participants and organizations. Last year, we arranged for 50 industry participants to undertake a medical assessment trial runs with satisfactory result. As for implementation, subject to the panel's endorsement in the coming 2 days, we're going to announce the implementation of this revised proposal. There will be amendment to the examination rules. They will be uploaded online. And also for the local COCs, we will, as well as the permits to be issued by the Marine Department, we will add this medical fitness requirement. I want to emphasize that only the new applications or revalidation of the local COCs will be affected, involving about 600 high-risk vessels. And for operators between the age of 18 and 65 who are not yet required to renew the applications, they will not be affected. Starting from the second quarter this year, we have been preparing for the launch of the new arrangements. We have prepared publicity leaflets, and we also have been liaising with the industry. So that concludes my presentation. Right, the floor is now open. Let's begin, starting with Mr. Chan Yong. Thank you, Chairman. Of course, safety is our top priority. But we do not have a lot of talents who are able to operate high-risk vessels. So we need to strike a balance. I understand that to ensure safety, you will introduce a medical assessment. But on the other hand, will there be incentives as a matter of policy to ensure that operators are more concerned about their physical health as well? Because we sometimes read from the news that there might be incidents that may happen to athletes who, say, for example, run marathons. So we need to make sure that they can take care of themselves and they are aware of their physical health. Otherwise, there will be an even greater risk. The other point is I see there is a transitional period. Meanwhile, whilst without compromising safety, since you're requesting a medical examination to be done once every few years, it may be too long an interval. So an incentive should be given for the operators to conduct physical checkups more frequently so that we can ensure safety and we will be able to retain talents. After all, we are an international maritime center and we'd like to keep and attract talents. Who will take this question? Deputy Secretary. Thank you, Chairman. Thank you, Mr. Chan, for the questions. Indeed, it's not just about the medical examination at intervals. We also mount publicity to ensure that these operators will be mindful of their physical health at other times. Right, I think what I meant to say is that there should be ways to attract new blood to the industry and to attract talent. It should form part of your strategy, or it should be incorporated in the rules. We have the Maritime and Aviation Training Fund, and through this fund, we provide grants to trainees, be it ocean-going vessels or local vessels. Apprentices do not tend to earn high wages, and that is why they rely on our grant as a financial incentive, so that when they become officially an operator or a coxswain, they can then earn a high income. As for health requirement, of course, we will step up publicity so as to attract talents. Dr. Chow Man Kwong. Thank you, Chair. Well, I think the main problem facing the industry is a succession gap. In October 2024, the Marine Department arranged for 50 industry participants to partake in medical assessment trial runs. So among these 50 industry participants, how many of them passed the assessment and how many of them did not? Second point, I understand that the medical assessment form is by and large a self-reporting form. So how do you make sure coxswains and other seafarers will provide accurate information themselves? My third point is this. For vessel masters, they are actually investors as well. So what will be the legal consequences for them? Because vessel masters may be held liable for the breach of laws by coxswains and seafarers, and that's a major risk.
Deputy Director, on your first question, if the applicants cannot reach the relevant standards, we will rely on the doctor's professional judgment. We have 16 questions which were drawn up by the medical experts. Information will be gathered from the applicants to ascertain whether the applicants are fit to operate on a vessel. And then we also issue guidelines to doctors, telling the doctors what are the standards related to each question. What standards will be adopted to ensure that the applicant is physically fit for operating on a vessel. If the applicant hides certain information or lies under the existing law, he breaches law, and we can deal with them under the law. And then on the medical assessment trial runs, on the 50 industry participants, how many of them have not been up to the standard? 47 have passed the tests, and 2 of them forgot to wear their glasses at that time. And after they have worn their glasses, they passed the test. And for the remaining one, he has some medical condition, and he failed the test. And then last question on the ship owner's responsibility. Let's look at it from 2 ways: application and also revalidation of licenses or COCs. This is very much related to the individual, and if the operator doesn't reach a standard, he will not be issued the COC. And for the 600 high-risk vessels, in the licensing, operating license, there is this additional condition added. So that's we say that the engine operators and the coxswains have to hold a valid COCs, and the ship owners have to be responsible for ensuring that is done. And if failing to do so, he is breaching the licensing condition, and there is a penalty at a fine of level 3 to be meted out. Any further follow-up? Dr. Chow, no. Mr. Frankie Yek, according to the paper, for those operating on Class 1 and Class 2 vessels, now after the legislation comes into effect, the operators have to undergo medical assessment every 5 years. Now there are different categories of the license, and I am on a Class 3 license, and 2 years later I would like to get a Class 2 license. Does it mean I have to undergo another medical assessment, or I would do it 5 years later? And then the deputy director said that 50 industry practitioners, among them, only 1 failed the test, and they accepted this assessment method. Their aspirations are twofold. There are now some 70 registered doctors who can provide the service. They hope that the pool can be expanded, and the cost is around $800. And they are asking for cheaper rates to be offered by the doctors. And can the government dish out subsidy as well? And Mr. Chan also said that the coxswains and engine operators are lacking in number in Hong Kong. We're happy that the LWB made an announcement on extending the supplementary labor scheme, and that these professions can be imported. Now, for imported workers, in the first contract, they cannot operate on a vessel yet. But the mainland, if for a operator coming from the mainland to Hong Kong, in the first contract, they have to try to sit an exam to get a license before they can actually operate on a vessel. So this can be very costly. So I think what the outside workers have to do is to get familiar with the local legislation and the local navigation channels. Do they need to sit for an exam, or they would be granted a license after attending some lessons? Deputy Director, thank you. On your first question, yes, they can use the same medical assessment to try to get a new license. So, for example, in the first year, they get a grade 3 license, and then 2 years later they get a grade 2 license. The medical assessment certificate lasts for 5 years, so he can use the same certificate to try to get a grade 2 license. And then the number of doctors, we've been trying to persuade doctors to join the scheme. Right now we have 88 registered medical practitioners. We try to get more doctors to join the scheme to help, to provide medical assessment for local seafarers. On the price, is around $800 to $1,000. I think this is a reasonable price. As to the shortage of seafarers, as what the DS said, we do have a number of government subsidy programs, support programs, enhancement programs for local vessels as well as ocean-going vessels. If a seafarer gets an overseas license and they can get a local license after sitting an exam. And I think the industry can get in touch with the Marine Department. We can make the necessary arrangement. On the third point, I will ask the secretary to talk to you. I think you have misunderstood my questions. For Class 1 and Class 2 vessels, medical assessment has to be undertaken once every 5 years. But I am operating on these vessels. I have two different types of, different grades of license. So after, say, I have been promoted to a higher grade, doesn't mean that I have to go through another medical assessment. So the medical certificate is valid for 5 years. So there is no need for you to get another medical assessment. If, say, the two licenses are 5 years apart, and he has to undergo another medical assessment. Deputy Director, from your angle, $800 to $1,000 may be reasonable, but for the seafarers, it's a bit on the high side. Mr. Edmund Wong, thank you, Chair. On this requirement, from the safety perspective, I do support this new arrangement. Now, we have to strike a balance between regulation and development. And Mr. Chen has talked about that. In the form, there are a number of different items. Hypertension, arthritis are also factors to be considered. And also emotional disorder and so on. Say, if I have a postnatal depression, is this something that would be considered? And it is more serious than, say, abuse of substance. And the administration said they would take the whole picture into account. I think it would depend on the professional judgment of doctors. You said that you have asked 50 industry practitioners to see whether the assessment works, and 49 passed the test. So are the trials runs stringent enough? At the initial stage, we tend to be more lenient. I can understand that. But if we are being too lenient, then I am worried, because we are talking about a box-ticking exercise here, and then the doctors just tick the boxes without any follow-up action. So by doing that, can we achieve the goals that we set out to achieve? And for this set of questions, have you taken reference from the requirements from international maritime organizations? So what reference have you drawn in coming up with this form? Deputy Director, on your first question, different diseases have different impact on a seafarer's operation on board. So when we compile this medical assessment, we are not talking about an all-rounded health checkup. We are using some simple questions, and through the doctor's professional judgment, we try to identify risk factors on the part of the operators. So this is very much a sort of way to assess risk. Say, for diseases like hypertension, as long as it is under control, diabetes, if the person is on medication and the blood glucose is being under control, so the seafarer is still allowed to operate on a vessel. So we have already struck a balance. So it doesn't mean that a person who is 100% healthy, only that person guided person is allowed to operate on a vessel. As long as the medical condition doesn't affect his operation on a vessel, then he can still operate, and the certificate can be issued. And we have experts compiling and got set of guidelines for doctors. We talk about 16 questions and 9 risk factors, and we set out the extent of risk which will make it dangerous or which have an impact on the operators operating on board. So there is this set of guidelines. We have also taken reference from international standards. Now, for ocean-going line vessels, the International Maritime Organization, International Labour Organization have already come up with certain standards, and the condition of operation on the ocean-going liners is different from that of local vessels. So, based on local circumstances, we have refined the standards based on the international standards. Mr. Chen Xiuhong. Thank you, Chair. To beef up maritime safety, the administration has introduced medical assessment form to ensure that coxswains and engine operators are fit enough to work on board, and especially for Class 1 and Class 2 vessels, new requirements are imposed. I support all these in principle. I've been following up on this, and I would like to further follow up. Now, the medical fitness certificate will be introduced. So what is the basis for that kind of requirement? And going by the paper, it is said that you have taken reference from practices in other regions, and you are adopting a medical assessment approach. And what we are worried about is that it's different from medical examination, which is a requirement on the part of coxswains in Class 1 vessels. So if the medical assessment is inaccurate, what will happen? That is a concern raised by several other fellow members. Say in the medical assessment form, there are questions. There will be visual inspection on the part of doctors. Should they suffice for the doctors to make a professional judgment? Of course, we trust the professional judgment of doctors, but we are worried why a medical assessment can replace science-based medical checkup or health checkup or medical examination. And in the past, there have been doctors who have professional misconduct and come up with some false statements and declarations and documents. So how can you prevent such things happening? And the administration said that you have taken reference from other places, and are our standards or practices aligning with those in China and other places, Europe, and say for those who are aged 71 or above, are our present practice similar to those of other regions? What reference have you made from other regions to justify your present practice?
Deputy Director. First, about the medical examination or medical assessment, what criteria we have adopted. In designing the medical assessment form, we have taken into account the 9 major risks that may directly pose a danger to the operation of local vessels. The second reason is that we rely on registered medical practitioners' judgment. Apart from the medical assessment form, we have engaged medical consultants to draw up a set of guidelines for the RMPs, and the registered medical practitioners will rely on the guidelines in assessing the condition of the applicants. Now, about the medical examination that is currently in place for coxswains of Class 1 passenger carrying vessels, In fact, we started this arrangement in 2016. We require the several checkups to be done, such as an X-ray, as well as the taking of blood pressure and blood glucose content, etc. We do believe a unified standard will better help ensure safety. As for referencing other jurisdictions, many of the jurisdictions we looked at adopt the same threshold of 65 years of age. But in fact, our country adopts an even more stringent threshold. That is, they don't issue licenses to coxswains above the age of 65. According to the age of coxswains, we will require more frequent checks. Next, Mr. Eric Yim. Thank you, Chairman. I think the new requirements seek to ensure maritime safety and the safe operation of vessels, so I support these requirements. About the medical fitness requirement, you will introduce a medical fitness certificate. I support that as well. But when it comes to the operation of vessels, you need to have regard that we have not only conventional ones, but also vessels that run on new energy. New energy vessels involve different risks, such as battery health as well as refueling. So, are there requirements in relation to the knowledge of coxswains on operating new energy vessels? Because there is a safety hazard if the licensees are not equipped with sufficient knowledge to operate new energy vessels. The second question is this. I understand that there is no age ceiling in relation to operators. The same goes for drivers of taxis or public transport in Hong Kong. We do not impose an age ceiling. But in many other countries, there is this upper age limit for drivers of public transport. In fact, at the panel on transport, I made the same point. For those driving taxis and public transport, especially those in the 80s, after all, we should set an age limit. This is only to ensure public safety, because if we allow somebody in his 80s to drive a taxi, it could be a moving time bomb. It will be catastrophic. So will you consider setting an age limit? Who will take this question, please? Deputy Director. Yes, the recent concern is on new energy vessels. Last year, we passed a piece of legislation to allow the use of new energy vessels in Hong Kong. And operators are required to undergo training. In fact, a few years ago, we introduced the same requirements for ocean liners as well as other new energy vessels. We have adopted the same arrangement in drawing up training courses for local vessel operators. Now, one of the requirements is that the applicants will need to undergo training before applying for a license. And for some vessel companies or manufacturers, they even supply their own training courses to the operators of new energy vessels. As for the age limit issue, indeed, I just explained that in some countries, such as the mainland, there is the age limit of 65. But for other jurisdictions, we have yet to see the age limit being set, and that those above that age limit must not operate a vessel. after introducing the new requirements, we'll keep in view the situation. At the same time, we need to have regard to the statistics because no statistics have shown that maritime incidents have anything to do with age of operators. Last to speak, Mr. Stephen Ho. Medical fitness requirements on applicants. I don't think in theory there is any reason for me to object to that. I just want more explanation given to the sector. Now, if my memory serves me right, your paper referred to 50 industry participants, and then there might be other conditions that might stir up fear among the passengers, such as high blood pressure, arthritis, and I remember on one occasion the form should have taken me 10 minutes to complete, but in the end I spent 20 minutes with the doctor because there were a lot of questions. Now I asked about this box ticking exercise. Just for example, if you have high blood pressure, does it mean that you'll be assessed not to be qualified as a vessel operator? In fact, it is more akin to driving a vehicle. There may be two minor points that may affect your license applications. Now, even so, if you're able to improve your health, since there are some 50 items here, maybe a fewer boxes will be ticked and that you'll be able to get a license. I discussed with the administration and then I've come to realize that the government has indeed been very proactive in ensuring maritime safety. At least the same has not been introduced for motorists. Now, like Mr. Eric Yim said, should we impose an age limit and stop those above the age of 80 from driving a vehicle? But this is an objective standard. Now you have different age limits, 65, 70, etc. So at the same time, like Mr. Chen Yong said, if you have high blood pressure and if you're stopped from operating a vessel, there will be a shortage of talents. Half of the practitioners in our sector will be shut out. So as I told the government at the meeting, I believe this medical examination fee is way too high. We should deploy technology. Say, when I applied for a driving license on the mainland, there is this device on the dashboard, and then it will alert me if a vehicle is approaching from either the left or right hand side. So with just this device, I get a lot of assistance, and I understand this is a transitional arrangement. If you're age 65 or above, you need to pay $1,000 for the medical examination. That means $2,000-3,000 a year. That's quite a significant sum. And if you are really senior, somebody may need to take leave in order to take you to see the doctor. Now, my other point is this. I don't know whether this happens to every district, but there is, it's only reasonable that if in a particular district there is a higher demand for healthcare services, then the fees tend to be higher. So I need the administration to give us more information about the fees to be charged by the registered medical practitioners. You should make sure that if the fees are exorbitantly high, the government will intervene. A final reminder. In fact, fishermen and the industry practitioners have called up my office and also Mr. Chen Hofeng's office. They ask about conditions such as high blood pressure and arthritis and whether with these conditions they'll be barred from operating a vessel. So you need to explain this policy well to them. Right, Deputy Secretary. Thank you, Mr. Ho. In fact, he has been giving us a lot of suggestions. They've told us, for example, in what districts doctors are in great shortage, and in fact, we've registered 89 doctors as recognized medical practitioners. So this is something that we will continue to do, and we don't impose a cap on the number of doctors joining this arrangement, and we'll also ramp up publicity. Now, for example, we are going to invite, for example, those who have undergone medical assessment to explain their experience in person so as to allay the concerns of others. And in the coming year, we will keep in view the situation in different aspects, including the fees for medical assessment, to ensure that there is a healthy market development. Right, I think we've completed this item. We should now move on to item 4. Thank you for attending. I say this to the administration. The next item is report on the work of the Competition Commission. Let me invite the administration and representative of the Competition Commission to come in. Members, if you want to speak, please press the request to speak button. Let me welcome Chairman, CEO of the Competition Commission, as well as public officers from the CDB. Let me read out the names of members waiting to speak: Luk Chung Hong, Andrew Lam, Chow Man Kong, Robert Lee, Eric Yim, Deputy Chair, as well as Chan Siu Hong. Mr. Samuel Chan, would you like to say a few words? Thank you, Chairman, members. Together with my colleagues, Mr. Russell Butt, Chief Executive Officer, Mr. Patrick Kwok, Executive Director Operations, as well as Mr. Lester Lee, Executive Director Legal Services, I'd like to report to members the work of the Competition Commission since the last report in May 2024. Simply put, we have been making progress on various fronts. In fact, we've submitted a report which sets out the details, and allow me to give you the salient points. On enforcement, we laid down the 3 enforcement priorities in the end of 2021. That is for cases that have a bearing on people's livelihood, abuse of public coffer, or the anti-competitive conduct that may affect the market substantially. We take priority, and we have actively investigated into a number of cases. We also mounted a joint operation with the ICAC in crack down on a suspected bid rigging case. We also conducted investigation on abuse of government subsidy schemes. In the past year, we have had a very busy schedule. Now, the Competition Tribunal last year handed down rulings on 2 cases in favor of the Competition Commission. As for 4 cases, the proceedings of which commenced earlier, the ruling from the tribunal will be ready soon. I'd also like to address another concern from members in relation to an investigation into petrol within the reporting period. That is last year. The investigation work came to a close. We exercised our power to conduct investigation and demand the submission of documents and information. We also invited the relevant persons to come to us. At this stage, however, we have not reached the threshold on initiating legal proceedings based on the evidence collected so far. So the Competition Commission is not going to take further action at this point. But I must emphasize that anything that affect people's livelihood will be something at the top of our mind. We will closely monitor the situation about the petrol fuel market. If there is evidence or there is any sign that anti-competitive conduct is involved, we will immediately take appropriate action.
On mainland and internationally, and the Competition Commission continues to deepen our collaboration with international counterparts. In February this year, we hosted this flagship event, which is a Hong Kong competition exchange, and over 4,000 guests from mainland overseas countries were gathered in Hong Kong to explore on how to promote economic development. During the reporting period, I and my colleagues visited Beijing and paid a visit to the State Administration for Market Regulation to exchange views on our work. And on public advocacy and education, the past year we have achieved good progress, and in that year we have launched this Small and Medium Enterprises Competition Compliance Hub, the SME Hub. The ordinance came into operation in December 2015, and by the end of this year, it is this year marks the 10th anniversary of that. And going forward, the Competition Commission is devoted to promote a level playing field, a fair business environment in Hong Kong, and I'm confident that the Commission will make contributions to the promoting economic development in Hong Kong. I'll now hand over the floor to Mr. Butt to supplement. Mr. Butt, CEO. Good afternoon. Like what is said, in the past year, the Commission has handled a number of litigation cases, and there is a first cartel case on the government subsidy program, and we won the cases, and a fine of $24 million has been imposed, and 3 individuals have been handed down the disqualification orders, and we have also resolved 8 cases, and we won in all 8 cases, and the tribunal has concluded trials of 4 cases, and judgments are pending, and these include the first case on the abuse of substantive market power involving medical supplies market, and there is also the first resale price maintenance case, and we expect the judgments of these cases will provide clearer guidelines to our law enforcement work in the future. The High Court has also handled a judicial review case, and that is related to the Commission's decision to refuse a leniency marker to the respondent in an state agency's price-fixing case. Judgment on the application is pending. And there is also another criminal case which involves a refusal to adhere or respond to the Commission's investigation powers. The person or defendant was convicted and sentenced to imprisonment for 2 months. And there was another trial going on last week. And this case has a strong deterrent effect. In local public advocacy and education, like what the chairman said, we are making proactive efforts to reach out to the members of the public and the business sector. This year, we launched the Small and Medium Enterprises Competition Compliance Hub. We are thankful for the SME associations for their staunch support in our efforts to launch this hub, and they have given us very valuable opinions so that the hub can meet with the needs of the SMEs. And positive response has been received. In the middle of this month, we would also be organizing a training program to further support SMEs to identify anti-competition risk and help them launch Competition Compliance Hub. Thank you, Mr. Butt. Now, I would like to ask Mr. Michael Look to speak 4 minutes each. On the powers of the competition, I think that the same question has been raised every year. And there are community views saying that the Commission's powers are limited and only under the condition when they have the reasonable cause to suspect will they be allowed to ask the suspects to hand over documents and information. If you have not an oversight of certain documents, it's difficult to come up with a reasonable cause to suspect. So is there any internal study on the part of the Commission on, say, asking the government for more power? And Chairman of the Commission, do you think that you are short-handed? If I'm not mistaken, you have only a few dozen staff members. Hong Kong has a bit complicated business environment, and you're handling so many complaints. Are you having a shortage in manpower? And then last year in October, there is a car manufacturer amending its car warranty manual in response to the Commission's concern, and that the car owners can choose maintenance services from other service providers. So the Commission has done good and real work here. Have other car manufacturers responded in a likewise manner? Have you been following up on these car manufacturers? I think there is some sort of monopoly in the car manufacturer market, and car owners are paying a high warranty or high maintenance price. Now, if, say, we talk about electric vehicles and all the distributors have to do is to push a button on the computer and say that your car is all right, but you are paying $2,000, $3,000 for that is unreasonable. Has the Commission investigated into such cases? Have you advised the car agents to do things better? Let me try to take the first question. I'll defer to Mr. Butt to take the second one. Thank you, Mr. Look, for your question. Investigation powers. We have discussed this multiple times. Right now, the power conferred to us through the ordinance is to collect information, gather evidence, asking the relevant parties to attend hearings and so on. We do have sufficient power. Like what the chairman, the CEO said, we attach a lot of importance to our powers. And in the past year, if individuals is not complying with our investigative powers, the person was convicted and sentenced to imprisonment. As to the threshold of reasonable cause to suspect, RCS, I think it's a sort of give and take situation. In other jurisdictions, the competition enforcement bodies agree that we should not have unlimited powers. In terms of staff establishment, we have a total of 77 colleagues. We also have over 90 staff on contracts. Compared to other jurisdictions, I think we're not doing words. If we are to expand our work portfolio and need more resources, then we can further pursue that. But right now, we do have sufficient manpower. Next, Mr. Andrew Lam. You've gone over time. If you want to ask, please press. What about car repair and maintenance, the agents? The Legal Services Executive Director? Mr. Look and other members may know that this is not the first case involving car retailers. Limiting the car owners on the maintenance service. A couple of years ago, There was a case on car retailers and the diesel oil cars, and were similar restrictions at that time. That case was similar to the present case. It has been resolved. Well, that is resolved by way of a commitment. So we have been continuing to watch over this market, and EVs are popular, so we have taken the initiative to contact other car retailers of different brands to know about what we are doing, and they can undertake preparatory work so that they would not be engaged in anti-competitive conduct. Mr. Andrew Lam. I remember many years ago, the government and the commission have looked into this. The merger rules, the application scope of that rule. To my understanding, there might be cross-sector mergers happening, and a number of different regions have the guidelines on those acts. But for the merger rule in Hong Kong, it covers only the telecom sector and not other sectors. Have you further considered expanding the application of the merger rule covering cross-sector mergers? If yes, what have you considered? If not, what worries do you have? Thank you. Chair. This is a question relating to policy. Thank you, Mr. Lam, for your question. Like what Mr. Lam said, in many other jurisdictions, most competition authorities have power in relation to merger rule. These are the three pillars. First is cartel. The second one is abuse of substantive market power, and then the merger rule. Personally, in my past few years of work, I have looked into the practices in other regions. While our country also has these three pillars, they have a very robust system. Hong Kong is an international financial hub, and we have a sound legal system. And we are proud of the rule of law in Hong Kong. So in the long term, I think we should have a merger recovering cross-sector mergers as well. I understand that in other jurisdictions, for newly established competition authorities, they might focus more on cartels and abuse of substantive market power. And when should we introduce this in Hong Kong? I think it's a matter of time. Like what the other said, it is also a matter of policy. And in the long term, a healthy competition policy or framework should have these three pillars. That is, the merger rule should also be included. Well, the merger rule covers the telecom and the broadcasting sectors, these two sectors. I hope that the government representatives can bring this back to the government and consider this again, because the Competition Commission has been up and running for some time. It's not something new. So I think it's worth considering going that direction policy-wise. Thank you.
Well, you have a little time left. Let's ask Chairman what he thinks. Should there be a merger rule for, say, financial services or other sectors? Well, I think it's quite difficult to include more sectors in the merger rule. We have made reference to other places, and as an enforcement agency, it's quite difficult to include these sectors. So I think that that means not only confining to the telecommunications or broadcasting sectors, but merger rule across the board, yes. This will be a more robust system, because otherwise there may be technical issues. Right, thank you, Chairman. I hope you will look into this matter and discuss with the Policy Bureau. Professor Chow Man Kong. Well, according to the Commission's report, every year they receive several hundred cases of complaint, but not many reached initial assessment concern, because for new cases there were only 7 of them, and as in April, and also just 1 case with investigation commenced. So we only had a handful of such cases. But of course, there may be complaints that are eventually not substantiated or are trivial in nature. So the Competition Commission should consider ramping up public education. That means the Commission should explain to the public the evidence threshold required in lodging complaints so as to enhance the efficiency of the Commission's work. But the next point is that from the figures, it seems that the success rate is really on the low side, and this is a big question on the efficiency of the Commission. You get $150 million of grant from the government every year, and yet you only handle a dozen cases a year. In other jurisdictions, there might be cartel in certain sectors, and we also have similar situations in Hong Kong. So will you take a more proactive approach and look into these cases? The third point is this. I see that for some cases, the investigation went on for more than a year. Is there room for improvement so as to expedite the work? The last question is this. In relation to the pilot scheme on third-party logistics funding, and also the distance business program, there is an abuse of public money. Will you work proactively with the relevant government departments and public bodies to encourage them to refer cases to you, so that you take a more proactive position in gatekeeping for the government against anti-competitive conducts or abuse of the public coffers? Who will take this question, please? Chairman, I will take the last question first, and that is in relation to cases of abuse relating to government subsidies. We do reach out to public bodies, government departments, especially those with a lot of public procurement activities. I understand for organizations with tendering exercises, they also draw up rigorous procedures. We reach out to these organizations, we invite them to tell us about suspicious bid rigging activities. In fact, recently, we invited the Hong Kong Productivity Council to give us data so that we could conduct analysis. And through data analysis, we identified suspicious price fixing behavior, and that is why we commenced the investigation. The case in the end was submitted to the tribunal, and the tribunal ruled in favor of the Commission. And the member just now asked about the number of cases undergoing investigation, and that it's not a big number. It involves some really complex cases, however. I'll give the floor to my colleague, right, Mr. Kwok? Thank you, Chair. I think members are very familiar with the legal framework. Indeed, we need to go through the initial assessment before we formally launch investigation with our investigation powers. But we are not just sitting on our hands. Based on the experience gained in the past decade, we cannot just rely on public complaints or referrals. We take a more proactive approach in collecting intelligence from different stakeholders such as ICAC, the police, as well as other departments such as URA. We take a proactive position in collecting information and practicing the so-called data mining so that we can have more information for analysis. Like Professor Chow just now said, he talked about the enforcement in other jurisdictions. Well, we adopt a very different approach. In other jurisdictions, basically, the competition authority is an enforcement agency, so it can exercise its own judgment. And only when the corporations disagrees with the with the determination will legal proceedings be initiated. Whereas in Hong Kong, we rely on the judiciary. That means we take the case to tribunal after going through initial assessment and investigation. And it's for the tribunal to decide on the matter. So do understand that this takes time, because investigation itself takes time, and it also takes time for the tribunal to determine the case. What's more is that we adopt a different standard of proof than other jurisdictions. The competition ordinance in Hong Kong does not specify the standard of proof, whether it should be one of a civil standard or a criminal standard. However, from case laws, we understand that the standard of proof is one of a criminal case that is beyond reasonable doubt. Only when we can prove the case beyond reasonable doubt will prosecution be initiated. So this means that comparing to an ordinary civil claim, we need much more time and resources. Thank you, Mr. Robert Lee. Thank you, Chair. We just received a report from the Competition Commission about the work in the past year, and I support their work. I understand they've achieved good progress across different facets, including anti-competitive conduct that hampers people's livelihood, international conferences, the establishment of the SME competition hub. Overall, I believe the Competition Commission contributes to maintaining a level playing field for businesses in Hong Kong. Now, I understand this paper places emphasis on enforcement, but I would like to know whether there is any emphasis on prevention. Instead of taking enforcement action at the later stage, I do hope that we can maintain a favorable business environment in Hong Kong much earlier. Well, as I understand, the financial sector or the financial services sector are mostly overseen by the SFC and Hong Kong MA. So I think it is important to work with these authorities to raise the awareness of the sector about anti-competition rules. Now, the second point is that whilst I'm happy to learn that resources are devoted to helping SMEs, such as the SME Hub, I want to know whether you have conducted any data analysis and that you are more inclined to investigate into cases involving SMEs. What about the big fish? There are different segments, different sectors. I just want to know whether there is an even distribution of resources for handling complaints. Who would take this question? The Executive Director? Chairman, I thank the member for his questions. Indeed, the major focus is on SMEs because 98% of businesses in Hong Kong are SMEs, so they play a pivotal role. But it doesn't mean we only have eyes on SMEs. We are fully aware of the resource constraints on SMEs comparing to bigger corporations. This piece of legislation is new to them. We don't want them to be caught inadvertently by the law, and that's why we have been devoting resources to educate the SMEs. But like the member said, there might be anti-competitive conduct across different sectors. There is a need to engage stakeholders in different sectors, and on this front, we have made a lot of efforts. Examples are the I&T sector and the construction sector. We've been sparing no efforts in helping them. According to the cases that we came across, we believe that these are the priority sectors we should reach out to first. We are a newly established organization. We may not yet have the opportunity to reach out to every sector. But anyway, we have seminars and training courses for, tailor-made for specific sectors. Thank you. Next, Mr. Eric Yim, Deputy Chair. Thank you. The competition ordinance tackles mergers that may have substantial impact on healthy competition in Hong Kong. Now, as explained, the competition ordinance and the merger rule in particular applies only to a very narrow scope, specifically telecommunications and broadcasting sectors. And that is a carrier license under the telecommunications ordinance. Will the Commission consider following our country's antitrust law so that the more statutory powers can be given to the Competition Commission to tackle more cases? Recently, the State Administration for Market Regulation has been tasked to conduct a specific investigation. Is there anything that can be done to align our rules with the SAMR's investigation procedures? Will training be provided? Who will take this question, please? Thank you, Chair. Thank you, Member, for the questions. Now, I think I already answered the question on whether there should be a set of merger rule across the board, and my answer is in the affirmative. In the long run, we should bring ourselves on a par with other jurisdictions. In the past few years, we have been liaising on a regular basis with the State Administration for Market Regulation, as well as the respective provincial and municipal authorities. We have learned a lot, especially in relation to compliance checks. Over the years, we have attended international and mainland conferences. We've come to realize that with merger rules, the overall anti-competition laws and policies can be further enhanced. So this is something that we will continue to work on. At an appropriate juncture, we will engage the stakeholders on improving the framework. So on the one hand, we do closely keep in view the importance of the merger rule.
Has he answered your question? For the Hutchison Whampoa Port sale, have you worked with the central authorities and departments to investigate into the matter together with them? Like I said, The merger rule in Hong Kong applies only to the telecom and broadcasting sectors. It doesn't apply to other sectors. On that premise, it's difficult for us to work with the State Administration for Market Regulation. Next one, Mr. Chen Xiu-hong. Thank you. In the past year, the Commission has done quite some good work. There is this first case involving the government's subsidy, and there is also a case involving non-compliance with the government's Commission's investigation powers, and the Commission has won. And there are other cases which are being handled and investigated into. The Chair, you might recall that at this Council, I have repeatedly said that if the powers conferred on the Commission by the ordinance are not sufficient for you to undertake your duties, we would be more than happy to give you more powers, to empower you, to help you do the best job. It is not just about the merger rule covering only the telecom and broadcasting sectors. If you think that there is a need to work on other sectors as far as the merger rule is concerned, please embark on a study as soon as possible so that Hong Kong can provide the best business environment for businesses. In the paper about education, the Commission has been doing fine, but in paragraph 13, it is said that in February 2025, the West Kowloon Magistrates Courts ruled on the first criminal case for non-compliance with the Commission's investigation powers. The defendant was sentenced to imprisonment for 2 months. That serves as a strong deterrent effect. And there, on the 27th of May, there's another case involving the Eastern Magistrates Courts. And this is this criminal case for non-compliance with the Commission's request to attend meetings. How can you make sure that the public knows that if they do not comply with the Commission's investigating powers and that they do not attend the Commission's hearings, the consequences can be grave, including being sentenced to imprisonment? How would you enhance public education? And I also agree that we should step up publicity among youngsters. And in paragraph 32, you said that the Commission rolled out the Post to Compete Advocacy Challenge in February 2024 with participation of close to 200 teens from over 80 schools. I've browsed through the relevant website looking for the competition results, and regrettably, I found that the champion's IG post has been deleted. That is most regrettable. This is a major competition to allow young people from the secondary schools to participate. We hope that what they did can serve as a publicity tool for you. I don't know why the posts have been deleted. Going forward, if you organize similar competitions, you impose an additional condition that you should not delete the materials that you use for entering the challenge. This is a very specific question. What I'm concerned is we should beef up the education and publicity so that the public knows more about the competition ordinance. Thank you very much for your question. First, about the 2 individuals for not complying with our investigation powers, and they are criminally liable. And the member asked whether we have embarked on sufficient education to make sure that people understand and are not unclear about our requirements. When you use mandatory powers, mandating undertakings individuals to furnish us with information or to attend our meetings, we let them know clearly that if you do not comply with our requests, you would be criminally liable. This is very clear. We would also be asking undertakings to furnish information for us. And sometimes they would ask us for an extended period to do so. When we ask them to come for meetings, they would also be asking for the meetings to be rescheduled. We would try to accede to the requests as much as possible, but ultimately they have to comply with our requests. So for these two cases, the instructions were clear. There is no doubt about that. And if there were cases and people were penalized, then these will be serving as a strong deterrent. We hope that these two cases will serve as a deterrent and will give clear messages for those who are under our investigation in the future. The member referred to our collaboration with schools to do publicity. The member referred to IG. I have to check on what's happening. For social media and for the challenge being held on social media, this is very much an annual event. We will do it every year. I thank you for raising the question. We will go back and look into the issue and make the best preparation for the next challenge. Next one, Mr. Frankie Yik. Thank you, Chair. Last year, when the Commission introduced your work, the chairman talked about an investigation on suspected price fixing on the auto fuel. I look forward to having good results, and you said that there's nothing you can do for the time being. I'm disappointed. I know this is not easy. I hope that you can keep up your good work. Oil prices are the highest in Hong Kong around the world, and I think that there is a strong reason to suspect that there is price fixing. I hope that you can keep up your work. And in paragraph 21, you talked about the car warranty manual. I believe that you were talking about EVs here, and then another official explained that for diesel oil cars, a similar case has arisen in the past. I thought that for all brands, there is no authorized maintenance service provider. You can patronize any service provider. Is that case? I would like to seek a clarification. And then thirdly, another member has raised this, whether you have sufficient resources. Can you expedite your work further? And in your briefing, you said that you have won in all cases, which means that you have adopted a very prudent approach because you are dealing the cases with really high criminal standards. So why I'm raising this, because you are talking about a case in concerning pilot subsidy scheme for third-party logistics service providers. There are results being meted out. I actually sat on the relevant panel, and I've been waiting for information or message from you. If judgment has not been handed by the court, I still have to grant the subsidy to the relevant party. And then if we do that, we won't be able to recover the public funds from that provider. From an outsider's perspective, even we know that there is a strong case that there is anti-competitive conduct. Should we stop dispersing the public money to them as soon as possible? Chairman, I note Mr. Yik's question about car distributors or car manufacturers' car warranty situation. The last case was in October 2022. We accepted 7 car distributors' commitment. And after that, we also liaised with other car distributors and notified them of such a case. And we also resorted to publicity channels to let the public know about this. And I'm sure that car owners know about this. When new car owners take their cars to have a checkup, and well, the staff of the car companies may tell them that there might be a problem with what they're doing, but then the relevant provisions have been amended, and the latest case involved an EV brand, and there is some ambiguity in this particular case, and ultimately, and actually, they have been proactive in amending the relevant provisions. So the case here is different from the previous case involving the 7 car distributors. In that other case, commitment was the way to resolve the case. So if you're going to buy a new car, well, the relevant provisions should have been amended. But then when the terms are executed, there might be a different situation. We would share the information with the car distributors of other brands. In Hong Kong, we do have the anti-competitive conduct requirement, and so that they were not caught and be caught inadvertently by the law. Last one, Mr. Jeffrey Lam. The paper mentions about publicity and education. I think this is a very important aspect of your work. The Commission had a good start, and then members of the public now are still not do not know much about the competition ordinance. Mr. Butt, you talked about exercising your mandatory investigative power, but then the relevant undertakings have not been complying with your request. Maybe you should beef up your publicity work. Maybe they know little about what the law is about. Mr. Chen Xiu-hong was from the CLP, and he would try to avoid seeing his competitor, the Hong Kong Electric. So people would try to stay away from the competitors. And maybe the 2 competitors will talk on the phone and say something about pricing, and they might be caught by one of the provisions under the competition ordinance. Now maybe you submit a quote to the customer, and for those who are submitting quotes cannot discuss among themselves. But then for some, say, overseas customers, someone from overseas countries, the buyers from overseas countries, they get the information, they would tell the suppliers, telling another supplier that I get a quote lower than yours, so you should cut your quotation as well. So does this constitute a breach of the competition ordinance? Well, a lot of people don't know whether these conducts will breach the ordinance. How would you step up your publicity so that businesses and members of the public know more about the ordinance?
Who will take this question? Mr. Butt, please. The Competition Ordinance has taken effect for 10 years already, and resource-wise, we place a lot of emphasis on education and policy advocacy. Exactly like the other member said, we don't want to take enforcement action at the later stage only when the law has been broken. We want to take a preventive approach, and that is how we mount publicity. The ordinance has taken effect for 10 years. meanwhile, we've conducted surveys. We asked the business sector whether they are familiar with the Competition Commission's function. The survey results show that the business sector is aware of the competition ordinance. However, there is a weak link in terms of the SME's awareness of the competition ordinance and the compliance awareness. There are inadequacies, and that is why we have devoted resources to help them in the form of, say, the SME hub and in holding seminars, etc., to help them get a better grasp of the competition ordinance so that they won't break the law. Now, I fully agree with the member that we should continue to mount public education. Right, so much for this item. Would the Competition Commission please go back and consider members' comments, especially on M&A? Please consider whether you submit a proposal to the administration. The next item is about low altitude economy. Now I need to leave because of another event, so Mr. Eric Yim, Deputy Chair, will now chair the meeting. Thank you. Is it coming through? Is the mic on? Members, we move on to the next item, promoting the development of low-altitude economy. We're pleased to be joined by Deputy Financial Secretary, Secretary for Transport and Logistics, Ms. Mabel Chan, as well as other government officials from the administration. They will be taking questions from the floor. Members, if you want to ask questions, please press the button. Right, I will invite the administration to walk us through this item with the DFS or the Secretary, please. Thank you. Ms. Joanne Hong, Deputy Secretary, will give a presentation with the aid of a PowerPoint, but let me just give three salient points. The first is that we are very grateful for the Legislative Council's support on the promotion of development of the development of the low-altitude economy. It's a perfect demonstration of good interaction between the legislature and the executive. Now, say for Ms. Elizabeth Quad, Mr. Chan Siu Hong, or Mr. Andrew Lam, they have told us about some really hot items, and that is how we managed to start these initiatives. The second point is that we are working at the very expeditious approach. Well, since the establishment of the working group, we have been inviting applications, and we've approved 38 so far. 7 of them have been kick-started. As I understand, last week we also submitted an item of subsidiary legislation to the Legislative Council. I understand that next Monday the meeting will be held. Now, for eVTOL and other unconventional aircraft, we need subsidiary legislation for the implementation of these projects. So with the passing of the subsidiary legislation, we will approve even more projects. we are hoping to launch another round in the first half of next year. The third point I'd like to make is this. As you may be aware, we attach a lot of emphasis on market potential, especially in terms of commercial application. I think we rely on the market to tell us where to go, and at appropriate junctures, the government will also step in to provide suitable assistance. In fact, last week, Ms. Elizabeth Quad, Mr. Chan Sil-hong, and Mr. Andrew Lam and myself at the meeting, and we mentioned the use of government buildings as vertiports for drones. Immediately, we invited the Government Property Agency and the relevant government departments, including the FSTB, to look into the matter. They have expressed support, and we will also be deferring to the Civil Aviation Department to make a report. Now, I will invite Ms. Joanne Hong to give a presentation. I'd like to brief members on the government's latest work progress with respect to the development of low-altitude economy, or LAE, as well as our vision. Now, as mentioned by the Deputy Financial Secretary, on the 20th of March 2025, we announced the projects covered by the first batch of the Sandbox project, or LAE regulatory sandbox, covering 38 projects. They come from public utilities, research institutes, universities, commercial, government departments. These projects cover a wide range of fields and application scenarios, including rescue and emergency logistics and distribution, infrastructure inspection, and safety maintenance. In order to know more about the efficiency and the safety measures, the Project Facilitation Task Force under the working group is working closely with our partners as well as the district councils. As you can see in this slide, there are 38 projects, and we also show the details of the applicants and the application scenarios. As mentioned by the Deputy Financial Secretary just now, in just 2 months, 7 of the 38 pilot projects have already been kick-started. As you can see on the slide, the first one involves drone delivery of goods. The second involves infrastructure surveillance. The applicant is CLP Power. And the next few involve Lands Department, Highways Department. They involve surveillance or infrastructure surveillance. The fifth one is the CEDD as the applicant. Now, they also attended a TV interview and introduced to the public about infrastructure surveillance, that is surveillance of slopes, etc. The next one is about building cleaning. Next, infrastructure surveillance. That means inspection and surveillance at construction sites. The applicant works in collaboration with the Development Bureau to conduct surveillance over construction safety matters as well as construction progress. The government also takes a multi-pronged approach in legislative amendments. There are 2 major legislative proposals submitted last week, including the Small Unmanned Aircraft Order, and that the scope of this piece of legislation will cover aircraft weighing more than 25 kilograms but not more than 150 kilograms. The next one involves Air Navigation Hong Kong Order 1995. Again, there will be amendments to facilitate trial operations of unconventional aircraft such as eVTOL, as mentioned by the Deputy FS. In the long run, we also plan to introduce a dedicated legislation for unconventional aircraft weighing over 150 kilograms. Good LAE infrastructure is essential in supporting the development and safe low altitude flying activities. So we will commence our work in formulating the model and requirements for a smart low altitude traffic management system. We will also map out requirements for radio communications network, potential air routes, as well as takeoff and landing sites. We will also work with the relevant government departments with a view to building a multi-tier development framework to catch up with the technological developments of low altitude economy, and would also enhance our liaison with the mainland so that we can align with their development. So on this front, we need to work on a number of things, such as the planning for radio communications network. The government is working with communications authority on a number of things, such as short-term spectrum assignments to allow the conduct of radio transmission tests. In terms of land planning, we believe the northern metropolis are well positioned to provide sufficient land and design flexibility to support the development. Now, on spatial data are important in planning, operation, and development of low altitude flight activities and application. The 3D visualization map has now been made available on the CSDI so as to provide rich spatial data for the sector. In the long term, we need to enhance our position because we're able to contribute our expertise in complementary services such as business planning, airspace and safety management technologies, aggregation, integration, certification, and insurance products to support the mainland's development as well. The working group is therefore engaging sectors. It is hoped that we can leverage the capabilities of stakeholders to build a good ecosystem. In fact, in May, the Project Facilitation Task Force organized an LAE workshop with a Cyberport. Over 200 industry professionals attended the seminar. We want to join hands with universities as well as business representatives so as to build an LAE ecosystem. In the long term, setting LAE standards can help industrial development and standardization. So we plan to establish unified technical safety regulatory service standards on LAE-related industries, including unmanned aircraft operation protocols, urban air traffic management, technical specifications of unmanned aircraft infrastructure, as well as personnel training, so that we can bolster our status and contribute to the development of LAE in our country. With these remarks, I conclude my presentation. Thank you. The floor is now open. Let me read out the names of members. There are 6 of them: Michael Lok, Chen Xiu-hong, Michael Tien, Elizabeth Quat, Perry Yu, and myself. I will give each member 5 minutes, questions and answer. Mr. Michael Lok, thank you, Chairman. I'm concerned about the amendments to the small unmanned aircraft order. As I understand, Category C aircraft, that means aircraft weighing more than 25 kilograms but not more than 150 kilograms, will be covered as well. Now, we see conventional unmanned aircrafts as in categories A1 and A2, as well as Category B. The legislative amendments were passed a few years ago. So far, we have not heard about major accidents. So, the majority of unmanned aircraft operators are law-abiding. According to the sector, for those practicing aerial shooting, they are subject to very stringent requirements. For categories A and B, at most, the clearance is less than 100 meters, just 300 feet or so. Is there room to relax the clearance? The second point is about the distance. Well, there is a very stringent requirement, and that the aircraft should be within your sight line. That means it should be within your sight line. You should be able to see it with your naked eye and not with a telescope. But then we have a lot of buildings. There may be things that can block your sight line. Can you relax this as well? Because we want to be able to have aerial shooting in a lawful manner. So will you consider suitable review to relax requirements? The other point is about insurance. As I understand, it's been put on the shelf at the moment. The insurance sector will provide the necessary support, and so that when it's implemented, there will be different insurance products available to give greater reassurance. On training, apart from what's mentioned in the sandbox project, there are other application scenarios. Training is needed. The Polytechnic University has established a low altitude economy research center, and the Hong Kong University also runs a master degree course on the same topic. So will there be any VTC operated courses for the general public? Say in the construction sector, even for cleaning services, there may be a need one day to deploy drones. Say for our assistants, we may ask them to use drones to take videos of an event. So can you make sure that more training courses are provided to the average Joe to make drones more popular?
3 questions. Secretary, on Mr. Look's questions, a brief response here. In our amendment exercise, in the SUA order, the Director General of Civil Aviation, where appropriate, can issue some safety requirements. Mr. Michael Look talked about the height. The main consideration is safety. And we heard about requests about flying beyond the sight line. And we have the pilot projects in the regulatory sandbox. In November last year, the Civil CAD has issued a small unmanned aircraft notice or instructions to simplify the relevant requirements, and there is enhanced transparency so that the practitioners who have undergone training can undertake drones flying beyond the sight line. And Mr. Look talked about training and insurance, and we have been in active dialogue with the insurance sector, hoping that they can offer more insurance products. And for talent training, well, you raised a very good comment, and we will actively consider and follow up. Mr. Chen Xiu-hong. Thank you, Chair. First, I declare that I am a senior consultant of the CLP. I'm pleased to see that the DFC and the Secretary for Transport and Logistics are the chairman and the vice chairman of the working group, respectively. That has to be commended. In a short space of time, we have built the sandbox from scratch. I think the chair and the deputy chair are very competent, and I hope that they can have a more forward-looking vision, and they have implemented the sandbox, and they are progressively amending the relevant legislation. And in paragraphs 16 to 19, it is stated that they have a long-term vision. So the LAE goes beyond pilot projects in the sandbox or any application scenarios. I'd appreciate the fact that the paper mentions that the Hong Kong has unique advantages in different complementary services, such as business planning, airspace and safety management, technologies, aggregation and integration, certification and insurance products to support the mainland's thriving LAE manufacturing and operation activities. And Hong Kong is a international finance center and aviation hub, and we are well positioned to set LAE standards. And we hopefully we can set standards for reference by other jurisdictions, and we can introduce a standardized LAE framework. In the past couple of years, these are my concerns, and this goes to show that the government is forward-looking, and we should be giving full play to our advantages within the context of the GBA. So my questions are related to cross-boundary collaboration. And paragraph 15 says that in addition to promoting local applications of low-altitude flying activities, the government is actively collaborating with mainland authorities to foster integration with the mainland's LAE ecosystem in terms of regulatory standards, infrastructure interoperability, and coordinated airspace arrangement. Which provinces and cities are involved in your discussion? Does it cover the 9+2 GBA cities? And as for our interface in terms of low altitude economy, as I advocated before, why don't you set up a cross-boundary low altitude working group? And then in the sandbox, I don't see any projects which straddles across the boundaries. I know that is not easy because CIQ and other issues are involved. I recall that Mr. Shandong, in the outline development plan of the loop, said that unmanned drones can be used for delivery of goods and services across boundaries, and there will be a sort of facilitation measures in relation to the loop's development. I don't see anything mentioned about cross-boundary collaboration projects. I'm very keen and anxious that you promote cross-boundary low-altitude collaboration. 2 questions there. Thank you, Mr. Chen Xiuhong. And thank you for your recognition of your work. And we attach a lot of importance to cross-boundary work. In November last year, I and my colleagues went to the mainland to have discussions. And this month, and some mainland officers came to Hong Kong to discuss with Ms. Joan Hong. I can share with you a few points. First, we were first on the cargoes of goods because passengers involve more complicated issues. We have some specific suggestions submitted to the Shenzhen authorities. And the Shenzhen authorities do have their own suggestions and proposals, and this is something good. And going forward, we will be proceeding with full steam on implementing these proposals. In the mainland, there are different laws and regulations governing LAE. They don't have some regulations governing cross-boundary low-altitude flying. And maybe you can work on some administrative measures. The sooner we can do that, the better. And the Security Bureau, the CNED are involved, and this letter said that they will fully cooperate with our efforts. And we will talk to the nearest neighbor first, Shenzhen, and later on, maybe to the GBA. My personal view is that if we can implement our efforts together with Shenzhen, we can further discuss with other cities in the GBA. What Mr. Chen said is something that can be explored further in the future. I think we should be pragmatic. We should first work with the Shenzhen authorities. Mr. Michael Tian. Thank you, Chair. Recently, the DFS and the Secretary, you know that Hong Kong's economy continues to be in a doldrum, and the retail sector has for 4 consecutive months recorded a drop in their volume. And normally, there will be a drop in the 12-month cycle only. And then in the 13th and 14th month, there should not be a drop in the retail sales. But now we are seeing that. That means that we are seeing a drop in the retail sales for 2 consecutive years, and that's a big problem. And in the community, there have been a lot of discussion on LAE, and they asked whether LAE can help salvage Hong Kong. How much can it help Hong Kong? Can it help with improving our budget deficit, increasing our GDP? A lot of people are involved or are working on it, and the country is also working on it. But what is our ultimate objective here? And in paragraph 14, you said the ultimate objective is to meet the needs of major applications, such as logistics, community distribution, city operation, etc. These are the ultimate objectives. What is the government's long-term vision? Do you aim to create new industries or replace existing industries? For example, courier of documents. If there are 100 documents which are couriered by workers, so if ALE is mature, then will we be able to deliver 130 or 40 documents? Or will LAE replace some of the workers in that industry? What are the main goals here? What are the side benefits? Now, if we have a bigger pie, so to speak, that would be best instead of replacing the existing workers. But if we are replacing the delivery personnel, these people will be unemployed. How will we deal with that? The country and ourselves would like to make a bigger pie, I presume. Will that cut down on the number of jobs? You have to find ways to help them. And then the GDP now every year is $3 trillion. If it can increase about 1%, $30 billion. What is your long-term vision for LAE development? Do you have a goal of, say, increasing the GDP by 1%? Now, I'm talking about the vision, not the projection. You must have a vision, right? Thank you. DFS, thank you, Mr. Tian, for your question. I'd like to share 3 points. First, to talk about the retail sales, which has just been announced yesterday. There are 2 positive points or developments. The drop has narrowed, but if you are looking at the figures on a rolling basis, on a 3-month basis, that's up by 4.4%. I know that the FS has just attended an electrical meeting saying that going forward, as the economy turns better, as many mega events are held in Hong Kong, tourism improves, then the situation will get better. Well, we are in the retail sector. I know where you are coming from. You can use the figures on a 3-month rolling basis. That's all right. Well, let's be hopeful. No, it's not going to replace jobs. I would not use the term or the expression make the pie bigger. We're talking about new quality productive forces. It's a change in the quality. We can do things better, but it doesn't mean that it's replacing the existing approaches. Shenzhen is moving faster than us. We should catch up. But a lot of workers are still employed in the delivery sector. Rather, LAE will create new opportunities for Hong Kong. If we develop LAE well, we can create opportunities, say, in the telecommunications sector, maintenance sector. There are new opportunities, say, in the country park. Say, if I would like to drink milk tea in the future, or maybe all I have to do is to call up a number and the milk tea can be delivered to me in a country park. So I'm talking about new opportunities.
Well, my question was actually on GDP. Let me make my third point. Now, it's not pragmatic to set a figure now. Let me share with members. For GDP contribution in Shenzhen, it's about $90 billion, 90 billion yuan. In percentage terms, well, they have a bigger population and a bigger GDP size. So by comparison, from our perspective, we just need to catch up. In terms of its GDP contribution, I am fully confident. And let me also say this, low altitude economy drives the development of other areas. As members must know, on INT, using my previous example, is not just about that cup of milk tea, it's about the front end and back end. Overall speaking, there'll be an overall enhancement. So I don't think we should just directly drop a figure. Well, my question is this, Chairman. In my constituency, people say they're pleased because it's now much more convenient. But happiness is not part of the economic development. It's all about the dollar sign. So despite all these glamorous tricks, when I ask the government what is your target GDP contribution, you should be able to tell us, because otherwise I'm confused. 90 billion yuan in the mainland, well, divided by all the cities in the mainland, that means 1 to 2%. Is that our long-term vision? If that is, then it's good news. Once we're able to include more projects in the regulatory sandbox, we will be able to have a better picture. Right, Mr. Michael Tian, if you want to ask questions in the second round, press a button again. We still have time. Miss Elizabeth Quat. I'm really pleased to learn about the rapid development of low-altitude economy. On different occasions, when I talk to industry participants about the development of LAE in Hong Kong, there is always this question whether Hong Kong is proceeding with the development. And let me tell you, we floated the idea last year, and very soon the chief executive included the initiative in the policy address. The working group was then set up, and now we have startup projects and regulatory sandbox. In July, we received the subsidiary legislation. So I can tell you that this is the new speed for Hong Kong. This is the speed we have now. This current government has shown resolve in developing low-altitude economy. So, like the Secretary said yesterday, we have adopted a new mindset, a new mentality, and a new approach. So, it's a new way for different sectors and for the public, and it's also a new hope for Hong Kong. Now, I really like to commend the government for the hard work, as well as the working group. They have started from scratch in building this new industry. Of course, as mentioned by other members, there are doubts as to the real contribution to our economy, as well as whether people will be driven out of their jobs. Now, when I attended exchange sessions with the Alliance on Low-Altitude Economy Development in the Greater Bay Area, people were very excited. In fact, just today, I talked to the property management sector, and they also asked about the application scenarios and how drones could be applied to clean buildings and inspect buildings. In the past, that would require a lot of efforts, not to mention money and manpower. It's also a risky operation. With drones and low altitude flying activities, we can save so much money and time, and our workers will be much safer in their operations. So the first question is, when will the projects in the sandbox come to fruition? When will we see these products in the commercial market? There is a big demand, and naturally companies will compete for business. And in order to achieve that, they will need to meet the standards requirements, and that means these activities will generate a lot of value. It will also create jobs. Now, Deputy FS, the Alliance this morning signed a memorandum of cooperation with the Hong Kong U Polytechnic University, Hong Kong UST, as well as a City University. Now, these universities have joined the alliance, and in fact, 2 other universities will have rolled out a master's degree course. It's been oversubscribed, and competition is really keen. This is proof that people have confidence in this industry in the future. There are high hopes for you, Deputy FS. I understand that today you may not be able to tell us the GDP contribution in percentage terms, but I think this is something you can look into in the future. Let us know how and how much the LAE will contribute to our GDP. As I mentioned to you before, Deputy FS, apart from promoting economic development, low altitude economy can also help improve the city's governance as well as urban management. But there is a problem of duplication of resources and the lack of data flow across different departments. So that should be a centralized platform. The other point is that the sector looks forward to the second phase of the regulatory sandbox, so that more application scenarios can be developed. And I think the crucial question today is when the projects can be commercialized. Right, I think Ms. Kwok's point, in essence, is that there is a new way out and there is a new hope for Hong Kong. Deputy FS, a brief response. Yes, I thank Ms. Kwok and other members for the comments, like Mr. Chan Siu Hong and Ms. Kwok. They have given us really direct feedback. They've helped us improve. So I stand to be corrected, but let me say that in the first phase of the regulatory sandbox, there are outstanding projects such as eVTOL projects that require the subsidiary legislation to be passed, and then we'll move on to the next round. As I've been discussing with Ms. Mabel Chan, the Secretary, we want to take a more systematic approach. We don't want to have trial runs only. We should make sure that we take steady steps whilst seeking progress. That means we should evaluate the outcome of pilot projects. As I explained, the contribution to Shenzhen GDP is 90 billion yuan. In Hong Kong, we have yet to come up with a figure because we want to lay a good foundation first. That's the first point. Second point, well, I think that this is good news for members as well. About this central database, we will actively look into this option. Next, Mr. Perry Yu. Thank you, Chairman. I fully agree with what Ms. Elizabeth Kwok said. The working group is able to achieve so much within so little time. It's really a new speed for Hong Kong. I am concerned about leveraging on LAE to help tourism sector upgrade and transform so that we have more tourist attractions for our tourists. For the unconventional aircrafts that are passenger carrying, of course, I understand we have a lot more steps to go through before tourists are confident in these products. So, of course, it would be good news if you're able to seek progress whilst maintaining stability in a much quicker way. But my point is really this. Whilst developing low altitude economy, I think we can develop low altitude recreational development. That means making use of low altitude flying activities. For conventional helicopters, for tourism purposes, they are really costly. It's beyond the affordability of the general public or general tourists. But there are other possibilities for low flying sightseeing activities. But we have a lot of red tape. The framework is rigorous. In the past few years, we explored developing hot air balloon sightseeing tours, but then we had to resolve a lot of issues because of safety concerns and requirements from the Civil Aviation Department, the FSD, so on and so forth. So it's really difficult to develop anything new in Hong Kong. There are also other examples such as gliding performance, as well as, say, motorized gliding, and then parachuting as a performance or as a sightseeing activity. These are common low-flying leisure activities found in places with beaches and coastlines. So I'd like to make use of this opportunity to ask the administration to explore these ideas without compromising safety so that we can develop more tourist attractions and optimize the use of blue-green resources. So that's my concern, DFS. Who would take this question? Thank you, Mr. Yu. And first of all, I thank Mr. Yu for acknowledging our development direction. Now, responding to the member's suggestion on low altitude flying leisure activities, the first step is to allow eVTOLs to take off. That means we need to pass the subsidiary legislation for the Director of Civil Aviation to approve some pilot projects. We can start with non-passenger carrying eVTOLs, followed by passenger carrying eVTOLs. I don't think it will take long because the technology is mature enough, and very soon these services will become available. Helicopters are expensive. eVTOLs, by comparison, are much cheaper. We don't need a pilot to fly the helicopter or the eVTOL. It runs on a battery. It doesn't require substantial capital cost. So when things are ready, we will see some low altitude flying activities tailor-made for the tourism sector. So there are other examples. I think we can put our heads together in the future. But we also need to be mindful about according priorities. eVTOL is an area that we find having potential. Two members would like to ask questions. I'll let them have a go first.
Mr. Chen Xiuhong, thank you, Chair. When we discussed LAE, we complimented the DFS and the Secretary for adopting new speed to take things forward. So you should come up with the appropriate speed to take things forward. And there is a saying in the mainland that all low-altitude activities must be safe. And in many tourism spots on the mainland during the holidays, there were accidents involving drones causing casualties. And the State Council said that we should accord priority to goods delivery rather than carrying passengers. So the public should be led to understand that we should not be taking things forward too speedily, or else the consequence can be dire. And for the mainland, the LAE development is taking forward in a steadily and prudently. And also, illegal use of drones has been cracked down on the mainland, because the consequences of using illegal drones and accidents can be dire. We can use sophisticated unmanned aircraft, and if we rush things through, then the sky may be swamped with unmanned aircraft. We must ensure that the unmanned aircraft should be regulated properly, and there should be a traffic management system to be put in place. The DFS said that it will explore into that. But there are different systems available in the market which have different pros and cons and different characteristics. It's not easy to build a low-altitude traffic management system. Let's do something at the Northern Metropolis. Let's find some airspace in the Northern Metropolis and try out a couple of systems and then pick the best. So DFS and Secretary, please look into that. Please expedite your work on building this airspace traffic management system. And on the infrastructure for LAE, where heavy commitment is entailed. We are facing challenges in our finances here in Hong Kong. Should we continue to use the government resources to build such infrastructure? Well, the world around, the PPP model is often adopted. PPP, private-public partnership, well, with the facilitation of the government, the airspace should be allotted to certain private parties, which can then undertake commercial activities so as to lessen the burden on the government in capital investment. I think we should start thinking about that. It is a time for us to start thinking about PPP. I'd like to listen to the views of the DFS and the STL on that. Thank you, Mr. Xiu Chen, for your very good comments. We would consider both. On the airspace management system, we would be looking into how best to do that. For the Northern Metropolis, there might not be many application scenarios because the place is still being developed. Maybe we should work on one district after another, so it works better in cost management. And we see eye to eye with you on that. And then on the mainland, there is this experience. The government can provide service. We can also procure the services provided by external parties. So we can adopt both approaches. If there are good services in the community and the government buys them, then it would be better. And this is also done on the mainland. In my reply to Ms. Elizabeth Quart, I said the same. If there are different departments have low altitude flying needs, then we would centralize all these needs and build a platform to address that. To ensure that we can finish with our discussions properly, I will extend the meeting by 10 minutes. Ms. Elizabeth Quart. Thank you, Chair. I have to declare I am a founding chairman of the Alliance of the GBA Alliance on Low Altitude Economy. And I know that the government is facing some hurdles. The government has been active in proceeding with sandbox pilot projects. We have received feedback. The TLB has been working very hard to help, but then when cross-department cooperation is needed, they face difficulties. If they have to place a container to receive goods at a certain location, electricity is required, and if land belonging to other government departments is needed, it's very difficult to get the consent of that other government department. It seems that not every department is committed to developing LAU. Maybe this is not their priority. Is not an important task for them. I hope that the working group can put more efforts in requesting different departments to support the development of LAE and the sandbox pilot projects. Just like AI, we have the LAE, so maybe each department can come up with a list on how they can leverage on these so that we can develop, the different sectors can develop better. If the departments would like to work on these themselves, then it would make it easier for the sectors to seek assistance from them. So interdepartmental collaboration is crucial. We also have the hydrogen fueled energy development strategy. When I worked with Mr. Chen Xiuhong on that, we started from scratch. And then the government came up with a policy on the development of hydrogen fuel. And there is a blueprint, and there is a top-level planning on that. And I hope that the working group can adopt the same approach in LAE development. Maybe a blueprint or strategy can be compiled so that everyone knows about the government's objectives. And for the development of hydrogen fuel, and there are public funds supporting important pilot projects and their development. For development of LAE, we see that first-class universities in Hong Kong would like to take part more in, say, R&D and so on. There is no dedicated fund on the part of the government to help the development of LAE. Maybe you can say you can apply for funding under the Innovation and Technology Fund, but there is no dedicated fund established. It may be difficult for the sectors, for the different pilot project proponents to apply for funding from these other funds. I hope that the government can lend more support to universities to engage in R&D work related to LAE. Thank you for your 3 questions. Thank you, Ms. Elizabeth Quart. Let me say this. The working group is responsible for coordinating work among different departments. I will not use the term top-down. I think it's more about collaboration and negotiation. Going by my own and Ms. Chan's experience, when we discussed the subject among government departments, Say, for example, we try to identify takeoff and landing sites. The government departments involved are very willing to accede to our request. I think it entails discussion rather than trying to coerce departments to do something for us. Well, what I meant by top-down is that the department heads should acknowledge and agree to the request, and then those beneath him will agree to help. So that's what I meant by top-down, is not compelling the departments to cooperate. The paper also sets out our strategies clearly, but whether we should resort to the use of a blueprint, maybe that gives a more complete picture. But when we gather experience from the sandbox, maybe we can come up with a blueprint. We will not do that in the short term. If you would know what the government is thinking, actually, our strategies have been set out in a number of documents already. Anyway, we would consider the possibility of compiling a blueprint. When there are projects which involve innovation and innovative elements, they can seek funding from the ITF. Well, I approached the commissioner of INT today. She told me that they have received a funding request already. So we have to be mindful about the overall financial situation of Hong Kong. But for now, we might not be able to set up a dedicated fund. I hope the members can appreciate that. My question is very simple. I am concerned about safety issue, and there were accidents involving drones on the mainland. We're very concerned about that. On Mr. Chan's concern, will the government set up a monitoring group on safety of drones to follow up on regulating the safety of drones? The DFS you mentioned about sandbox, and we need a number of takeoff and landing sites, and these sites are now limited in number, and the government buildings can provide such sites. And for private buildings, the roof may be suitable for building takeoff and landing sites. Some private developers may be willing to provide the building roofs for such purposes. Would you be approaching more private developers, asking them to provide takeoff and landing sites on their building roofs? Can you give us a list of the developers or the sites so that the 30 or so pilot projects in the sandbox can find suitable sites for taking off and landing? I'll defer to my colleague to talk about the safety issue. I think your suggestion is very good. If private organizations are willing to provide takeoff landing sites, they can approach the working group, and we will also proactively approach building owners. The sites cover only an area of 2 meters or 3 meters, 2 meters by 2 meters only. And of course, electricity has to be available. And if private building owners are willing to take part in that, we're more than happy to talk to them.
Mr. Chow? Well, the CAD attaches great importance to safety whilst taking forward these projects. So we do actively liaise with the project proponents to make sure that they have safety protocols and also contingency plans for different scenarios. We also have different measures. For example, we have a restricted zone for different sandbox projects to ensure public safety. Another point I'd like to make is this: apart from oversight on safety matters, we also facilitate development by, for example, holding workshops to share with the industry the experience in beyond the line of sight operation, so and as well as the 3D map, so that we can take forward the sandbox projects without compromising safety. Right, it's now 7 o'clock, so that wraps up the item. Next, AOB. If there's nothing under AOB, the meeting is adjourned. Thank you, DFS Secretary and other government officials for coming.